welcome to Zoom with Czarny. I'm Dustin Czarny. Today it's Thursday, July 6th, and I'm very happy to have my friend and frequent guest, Tom Keck. Professor Keck from Syracuse University is one of the area's foremost experts on the United States Supreme Court, and we had some incredible decisions. By incredible, I mean, well, probably the worst way to take that. Just this last week, although there were some bright spots. And we have a very long and informative discussion on that. So I hope that you will tune in and stay for the interview. The June primary is continuing to go. We are going to be tabulating our absentee ballots later today, and then determining whether any race needs to go to a hand count, which will be next week, or certifying the election on July 7th. We will certify for all races and then recertify after the hand count if that's necessary. So some of these races can be called tomorrow, or actually probably Friday. But so that's what's going on at the Board of Elections. So you tune in to my social feeds this week, and I'll let you know exactly what's going on going into next week. But please stay tuned for my interview with Professor Tom Keck, one of the area's foremost experts on the United States Supreme Court and the decisions that were handed down. We have a great discussion about that, so I hope you stick for the interview. Bye-bye. And we're back, and I'm very happy to have my good friend Tom Keck of the CNY Solidarity Coalition and a professor up at Syracuse University. We've done this a few times now in the last, since the rise of the arch conservative Supreme Court. After, I think the first time we did this was right after Justice Bader Ginsburg's death back in 2020. But I'm always happy to have Mr. Professor Keck on, because it's almost like therapy for me to kind of go through what's going on, and there's nobody in our area that is more knowledgeable about the history of the Supreme Court and also the current cases that are before us than Professor Keck. Tom, thank you so much for coming back on Zoom with Czarny.
Thanks, Dustin. Glad to be here as always.
Well, I think we would rather be here on good news, but but as always, it seems like the end of the Supreme Court session, especially the summer session, has brought about some major changes. And last year we had the Dobbs decision, which ended protections for abortion nationwide and sent it back to the states. And we saw how that's worked out over the last year. And we've had some doozies of cases at the close, and maybe a couple of moderate, decent cases as well. But I guess I just want to hear from you, Tom. What is notable about this last session, and what are your top line thoughts? And then we'll get into the individual cases.
Sure. So, this time of year, lots of journalists are writing up end of term wrap ups. And this time last year, the theme of those was very clearly, this is an aggressive conservative court that appears impatient to push the law dramatically rightward as, quickly as they can across multiple fronts, right? The biggest issues last year were abortion and gun rights, but there was some other cases as well. So this term, from one angle, it's more of the same. So we see, for example, an aggressive rightward push on affirmative action. So that's very similar to the cases from last year. On the other hand, as you just kind of alluded to, right, there are some cases, particularly in the voting rights context, that came out in a different way. And I would just to frame the discussion, and we can talk about some individual cases, but to frame the discussion, the one kind of big takeaway I would just emphasize is that on the current court, basically all of the politically significant cases represent efforts by conservative lawyers to move the law sharply rightward, right? Because lawyers know what the current court looks like. So liberal lawyers are not trying to bring blockbuster cases to this court's attention, because that just seems like a bad idea. Conservative lawyers are very aggressively trying to bring blockbuster cases to this court's attention, and they're trying to use those cases to move the law aggressively rightward. And what that means is, in these politically significant cases, there's basically two possible outcomes. Possible outcome number one is that the court moves the law aggressively rightward. Possible outcome number two is that the court doesn't, which just means the law is staying the same, right? Which is better from a liberal democratic perspective than the alternative, but it's not like the surprise liberal victories are, it's not like the court is moving the law leftward in those cases. The court is literally just rejecting an aggressive conservative attempt to move the law rightward, right? And so it's good that there's a couple of those cases mixed in the mix this year. That's good, but I just want to temper it's like, again, the court is only moving the law in one direction. And the fact that it doesn't move the law sharply in that direction in every case is good. But it's like, it's still very clearly a conservative court.
Yeah, and I think that would be, kind of a good way for us to talk about this court here. And we'll start talking about the good cases. But I'm of the same mind of you. It's not that they pushed anything leftward. It's not that they made any new law. They just, in these cases, rejected incredibly wacky theories of how to strip down the Voting Rights Act and also empower state legislators beyond what the Constitution clearly says, and just rejected far right theories of the case, and just kept existing precedent in place. And then, of course, in the three cases that are most notable on where they really went far on the affirmative action and the 303 website case, which we'll get into, they really did throw out precedent and rules on standing to come to a conclusion that was very right of center, and so really changing the law directly. So, but let's talk about the two cases that were kind of a glimmer of somewhat sanity in these cases. That was the voting rights case from Alabama, and then of course the independent state legislature theory case. And we'll start with the Alabama case. This is the one where they did rule that Alabama had drawn constitutionally illegal lines on racial gerrymandering and a violation of Section 2 of the Voting Rights Act, and are ordering redraws of those lines. Why is that significant? I mean, why is that such a important case?
So this case, Milligan versus Alabama, was the most surprising development of the term for me. I was actually on a panel at the Syracuse Law School, earlier in the spring, where folks were talking about this case, and some of the litigators and participants in the case were there. And what I said at that time was, under existing law, right, existing interpretations of Section 2 of the Voting Rights Act, the voting rights advocates had a very, very strong case here, right? It seemed really clear that Alabama had violated the Voting Rights Act by basically packing all the state's African-American voters into a single district to avoid creating two districts that might elect Black Democrats. And we know they had a strong case because the lower court panel that ruled in their favor had 3 judges on it, 2 of whom were appointed by Trump. And they unanimously ruled in the voting rights advocates' favor because, just again, under current law, they had a really, really strong case. So I said all that, but then I said, but I still think the Supreme Court's going to rule against them because the current Supreme Court seems so dead set on shifting voting rights law rightward. They've undermined the Voting Rights Act of 1965 in several different cases, and it seemed like they were determined to do so again in this case. And it wasn't just a general trend, like looking what they had done in other related cases, but in this specific case, the court had issued a preliminary ruling on its so-called shadow docket, which we can talk more about, where the courts, before they had even received the arguments or heard arguments in the case, the court just temporarily overturned the lower court to allow Alabama's map to take effect and be used in last year's elections. And that was a very clear indication. And that decision was 5-4. Chief Justice Roberts dissented from it. He joined the liberals. But it was a very clear indication that the other 5 judges were likely to rule in Alabama's favor, right, and uphold these maps. And then they didn't, right? And so that was the biggest surprise to me. And something shifted between the court's early look at the case and its final decision. And it's a great victory by those civil rights advocates. It was lawyers with the NAACP Legal Defense Fund and other groups. It was on the ground voting rights advocates in Alabama. The named plaintiff in the case, Evan Milligan, is a longtime voting rights advocate in Alabama. So props to them. They did a great job with the case, and it's important that they won it. And it was very surprising to me.
And when the shadow docket ruling was done, wasn't that where Kavanaugh was the flip, right? He went from 5-4 against to 5-4-4, and Kavanaugh and the majority held that it was too close to the election, even though it was like in January or something like that. It was incredibly early in the year, and it was too close to the election to change the lines. And that's why they ruled it that way, to allow the lines to stand for that election. And now they have to redraw it. So, I mean, the flip is Kavanaugh. So you wonder if some of the public perception about the legitimacy of the court got to him. I mean, it seems like him and Roberts are the two most likely to rule, in a way that it will least affect the court's legitimacy so far.
Yeah, sometimes Justice Barrett as well. And it's hard to know for sure, but it does, the court has gotten a lot of flack since Dobbs. It's gotten a lot of flack in particular about its voting rights decisions. It's gotten a lot of flack about its use of the shadow docket, which means it's like emergency procedures short of hearing full arguments in a case. It's apparently kind of one-sided use of that docket to promote conservative results. And so it's really hard to know for sure, but it seems like Roberts, Kavanaugh, and occasionally Barrett might be responding to that kind of pushback.
And then, of course, the other case is the one out of North Carolina, which was the independent state legislature theory, this novel theory that only the state legislators had control over voting rights, and that even state courts were not allowed to overrule them, based on their state constitutions. And that's, that was a 6-3 decision, if I remember right. And this is where Barrett joined Kavanaugh and Roberts along with the liberal wing to, this one kind of surprised me because they had an out, right? They could have just said it was moot because the North Carolina Supreme Court had flipped in the time period, went from a Democratic Supreme Court to a Republican Supreme Court and was rehearing the case on the lines. And they could have said, well, it's moot now. It's going to be overturned in the state court, so we're not going to rule on the question. But they did. They ruled on the question. They said that the state courts have authority over the state legislatures. They're, the checks and balances of our Constitution are actually real, and but also they kind of opened up the door for the Supreme Court to look at state court decisions as well. Why don't you? I kind of briefly explained it, but why don't you go into that a little bit?
Yeah, so a lot of different things going on here, right? So it's again just like a little bit of backstory. So partisan gerrymandering is a big problem. Voters, voters across the political spectrum, if you ask them in public opinion polls, say it's a big problem. folks for years tried to get the Supreme Court, the U.S. Supreme Court, to do something about it. And in a case from North Carolina a few years ago, Rucho versus Common Cause, the Supreme Court said, no, we're not going to fix it. Yes, this appears to be a blatant partisan gerrymander by the Republican legislature in North Carolina. Yes, we think that raises like constitutional concerns if the party in power is intentionally using the map drawing process to entrench its hold on power. That seems troubling to us, but we don't think there's anything in the Constitution that authorizes the federal courts to fix it. Okay, that's what they said in Rucho. So they kind of duck, they kick the ball, leave it to somebody else, whatever metaphor you want. They said in that case, this doesn't mean there's no checks at all. They said, for example, state courts are still in place, and state courts could potentially review partisan gerrymanders under their own constitutions if they wanted to. So then folks in North Carolina got the, at the time, Democratic majority state Supreme Court to put some limits on partisan gerrymandering. And then conservative lawyers representing the state legislature come up with this independent state legislature theory, which again, as you said, is like a super aggressive theory to try to basically kick state courts altogether out of the process. It would be a really dramatic change in constitutional law. It would have really sweeping implications. There were a bunch of interesting amicus briefs filed in this case by voting rights experts and others, just identifying like hundreds and maybe even thousands of different kinds of like state laws that might be affected by ruling in favor of the independent state legislature theory. So I think some of the justices were concerned about the sweeping implications, right? The justices are also concerned, as we just discussed, with the pushback against the court's aggressive undermining of voting rights. The justices also may have been concerned with the uncertainty generated by the independent state legislature theory. This may be why they decided to go ahead and decide the case now, even though they could have dismissed the case. The independent state legislature theory, if the court had accepted it, or if it was still hanging out there as something they might accept, could potentially be the avenue by which Trump or others would try to undermine the outcome of the next presidential election, right? By getting state legislatures to sort of reverse the result after the fact. And I think partly because of that uncertainty, maybe why the court went ahead and decided it. So let's just, whether we're going to rule in favor of it or against it, it's a good thing for our democracy if we just get this big legal question settled for now. And then the last point that you mentioned, so Roberts and Kavanaugh and Barrett joined the liberal justices to reject this theory, and so that's good. They did, however, preserve a kind of ill-defined role for the federal courts, especially the U.S. Supreme Court, in supervising state court supervision of state legislatures in the electoral context. So, right, they said very clearly, state courts still have the authority to enforce their state constitutions against their legislatures. But if a state court was kind of acting outside the bounds of normal judicial review, basically the implication seems to be if the state court is just making something up in order to thwart the will of the state legislature, that's not really rooted in the state constitution, well, then, of course, the U.S. Supreme Court could still step in. And what that standard actually is going to mean in future cases is not clearly defined at the moment. And so some election law experts have written about this part of the case and said it creates a potential for future mischief if conservative justices kind of want to use it. I still think it's fair to say that the takeaway headline from this case is good news. It was an aggressive and potentially destabilizing conservative constitutional argument that the court clearly rejected. And so that is good news. Yes. Oh, I lost your audio, Dustin.
Again, sorry. The good news is they didn't throw out all the law. You know, they didn't throw out precedent in these cases. They've ruled consistently that how the Supreme Court has ruled in the past on racial discrimination. And again, the Alabama case is about I mean, it's a textbook racial, violation of the Section 2 of the Voting Rights Act. Not even close. If they were to let that stand, they basically would have been gutting the law entirely, like they already gutted Section 5 of it. They would have gutted Section 2, and that would have been a bad thing for Roberts, who had said when he gutted Section 5 that Section 2 still exists, and thus pre-clearance didn't need to be there because you could take these alternative actions. And then and then of course this independent state legislature theory was just absurd. And but what before we go into some of the bad cases, the three really bad cases at the end of the term that came down, what do you think are the net results of these two cases? I do see a lot of voting rights activists, cheering these two. They think that it's going to lead to fairer maps in Alabama, possibly Louisiana, possibly North Carolina, possibly Georgia and Florida, where other racial gerrymanders happened in 2022, and that they may eventually get fairer maps or another minority opportunity districts out of those states. But what do you think is the net? What is the most likely path here of what we're going to see come out of these two cases?
So I think the most immediate short-term result is that for Black voters, particularly in the South, they're going to have an opportunity to vote in fairer maps and elect a couple additional Black Democrats in the South. And given how close partisan control of the U.S. House is right now, that could make a difference in terms of control of the House. But whether it makes a difference for that, it's clearly better for those Black voters in those southern states where their legislatures were, again, intentionally packing them into a small number of districts to reduce their influence. So that is good short-term news. The second kind of implication, kind of looking ahead to next year's presidential election, right, is just taking away a sort of big kind of element of uncertainty, right? And it's, if you think about, right, also Congress last winter revised the Electoral Count Act in a bipartisan deal, that the combination of Congress revising that kind of 100-year-old law and the court getting rid of this radical new theory takes away some of the specific avenues by which Trump was trying to steal the election last time, right? It clarifies the role of the vice president in the counting of votes, that kind of stuff. And it's clear, the court is saying we're not going to let state legislatures, just ignore their own constitutions and steal the elections after the fact. So that's really good. Does it remove all possible doubt and all possible ways somebody might try to undermine the next election? For sure not. But it corrects some of the problems that we saw in 2020, right? And so that's really good news. Longer term, voting rights are still kind of in a somewhat weakened state nationally, right? We have lots of state legislatures that are aggressively trying to undermine them. North Carolina is a big fight right now, there is, the lesson of American history very clearly is that we need federal safeguards against voter suppression at the state level, and the 1965 Voting Rights Act provided those safeguards. The court has undermined it, kicked some big holes in it. There's been ongoing long-term efforts by congressional Democrats to reinvigorate federal voting rights law, and those efforts are still super important, right? We've dodged a couple bullets here, but the overall sort of imbalance is still there, and we need we need new and more robust federal legislation protecting voting rights against state suppression. And so congressional Democrats need to keep fighting for that.
And I think we do need to move on to some of the bad cases that they decided. But there are two other cases that I think we could just note real quick and then move on. Is that the immigration case where the states were trying to block Biden's authority to enact immigration law, and the Indian Child and Welfare Act that that allowed for Native American parents to be able to have first right on adoption, on a federal level. Those were also decisions that again upheld existing law, but they were, and this is where like Gorsuch played a weird role in the Indian, Child and Welfare Act case. He loves Native American law. He's been an advocate of that his entire career. So not necessarily surprising, but still kind of surprising that that was not taken. And again, and the states not being able to usurp the president's authority on immigration policy. I don't know if you want to talk about those briefly, and then.
No, I'm happy to move on. I mean, you're right about Gorsuch. He's been remarkably strong on Indian law issues, and nobody that I've yet seen has really given a good explanation exactly of why. Everybody's always like, well, he's from out west, he's more familiar with Indian law than the rest of the justices. That's not really an adequate explanation. And the striking thing is when you read those opinions, like it's not just that Gorsuch is ruling in favor of the Native American nations, claims, but he's writing passionately about the history of government mistreatment of Native Americans. And like it's so striking. I mean, if you read those opinions, it sounds like he has a quite robust understanding of like structural racism directed against Native Americans, and nothing similar comes through in cases involving race in other contexts, right? And so it's really a striking contrast.
We should really give him a history book about 1960s and the racial conflict that happened, in all, of course, the hundreds of years of racial conflict with, African American voters. And it would be nice if he showed the same amount of passion because he was on the opposite on the Alabama case and opposite on what we are about to talk to with affirmative action. So, but good for them. They had 4 cases that were upholding the law and not radically changing the law. But now we have the 3 cases that they ended their session with, which were just gut punches to our multiracial democracy that we have in place. And I'll let you chime in on any of them, but basically it's the student loan forgiveness, limiting the power of the HEROES Act, and again using their made up major questions doctrine to decide that, and then of course the striking down of affirmative action, saying that the 14th Amendment of the United States does not actually say what it says, that it's reverse discrimination, and then of course the major blow on the 303 website, which stated that if you had a religious belief, it's okay to, and this is my editorializing, but if you had a religious belief, it's okay to discriminate against LGBTQ, in the open marketplace. So pick any one of those and we'll start with that.
So they're all 3 important. I think I'll start just by highlighting a couple common themes across the 3 of them. So one issue is that all of them reflect efforts by conservative litigators, sometimes private lawyers and sometimes state governments, but conservative litigators to, again, aggressively push the law in a conservative direction, right? They know that this is their moment of opportunity. They have a robust conservative majority on the Supreme Court, and they're going for broke, right? Conservatives have been litigating against affirmative action for 50 years, but the court had always adopted some kind of compromise position that put some limits on affirmative action, but allowed some versions of it. But they knew this was their moment to get rid of it once and for all, right? And so they pushed these new suits. The student loan program was challenged by a bunch of state governments that don't like the Biden administration. 303 Creative was that suit was brought by evangelical Christian litigators, right? So that's one common theme. A second common theme is just how aggressive the justices are being, right? One thing that you see in both 303 Creative and the student loan case is that the alleged injury to the parties that are bringing the suits is basically fictional, right? There's really not an actual conflict. The Biden administration's like legal strategy on the student loan forgiveness, they knew it was vulnerable, but their hope was that there's really nobody that's harmed by this policy, right? If we say every student loan borrower with underneath this income cap is eligible for whatever it is, up to $10,000 of debt relief, that policy does not harm anyone. And you ordinarily cannot get the Supreme Court to hear a case unless you actually have some concrete legal injury, right? You can't just go to court and say, I object to this policy. That's not how the court works. They don't issue advisory opinions. They just decide actual cases. But the court in these cases, especially the Colorado free speech case and the student loan case, really, I want to say, like, butchered traditional legal principles regarding what counts as an actual case, an actual controversy where somebody's rights and interests are actually harmed such that we should decide their fate. That was not present in the student loan case, right? It's a bunch of state governments who were not in any way harmed by this policy. They just objected to it on ideological grounds, and the court ruled in their favor. So I'll stick with that case for a second. So if you read Kagan's dissenting opinion in the student loan case, it's very clear on this, right? So the court shouldn't be deciding it at all because these states do not have standing, and her discussion of those requirements is much lengthier and, in my view, much more compelling than Robert's discussion in the majority opinion. So then they're going to reach the merits, and they decided based on, as you said, this major questions doctrine, which the conservative justices literally invented a few years ago, and they have now used it repeatedly to rule against Biden administration policies that they don't like. They struck down the COVID-related eviction moratorium on those grounds. They struck down the COVID masking or testing requirement for private businesses on those grounds. They struck down a couple major environmental regulations on those grounds. So they shouldn't be deciding the case at all. And then they're deciding it on the basis of a made up doctrine that allows them to just sort of rampantly rule against democratic regulatory priorities. And Kagan's dissent in that case is really, really sharp and strong on this is a sign. The combination of these things is a sign of a court that's not really acting like a court, right? The court is like aggressively trying to reach some conservative results. And that is, we expect more and better of our Supreme Court.
So let's dig into these cases individually. I mean, and you're right. And I think Kagan took the opportunity to read her dissent from the bench, which is something that is not really done all that often as well, just to be able to emphasize how passionate the dissents are in these three cases. But
I know Sotomayor did so in the affirmative action and the 303 creative cases, and I can't remember if Kagan also did so in the student loan case. But you're right; that's a signal that the dissenters are very kind of worked up about the decision. They don't do it that often.
And even Roberts, in one of his majority opinions, and I can't remember which case, went into length about chiding people for talking about the court's legitimacy when they don't like the rulings that are coming down. So we know that they're hearing that. We know that they're feeling this pressure, but the rulings still are coming down in a way that are troublesome. So let's start in the order in which they were handed down. So we had the student was it the student loan first? I can't remember now.
It was affirmative action first.
Affirmative action first.
303 creative and student loan came down on the last day.
So let's talk about the affirmative action case. And I saw we're recording this on Monday, and I just saw that there may be some backlashes on this on legacy emissions as well, where some rulings or some cases are going to be as an answer to this. There are some people that might take colleges to court about legacy emissions, but what it did was in the Harvard case, and they ruled it in two separate cases, and the ruling was different because Ketanji Brown Jackson decided to, withhold from the Harvard case and recuse herself. But it was 6-3 and then 6-2. But for the what was the other school? It was Harvard,
Chapel Hill, University of North Carolina.
Right. So now that these rulings have come down, what is the effect that this is going to have on our you're in higher education, in our higher education system?
So a couple quick sort of contextual facts. So first off, there's like 4,000 colleges and universities in the United States or something. The vast majority of them don't practice affirmative action in student admissions at all, because the vast majority of colleges and universities are not actually selective, right? They're basically eager for students. They just want everybody to come. So it's really, we're talking about a handful, I don't know, 100-ish of the sort of most selective colleges and universities in the country. And those colleges and universities are selective, right? So like Harvard gets a lot more applications than it has spots for. And so they're faced with the task of deciding how to assemble an incoming class. Those selective colleges and universities clearly do consider race, right? I mean, and they long have. It's not the only non-academic figure or component of applications that they consider. They consider a whole wide range of different kind of factors. And there's really a fundamental disconnect between how university administrators think about the admissions process and how conservative lawyers and judges think about it, right? And in the university's minds, what we're trying to do is assemble a diverse incoming class that will be a beneficial create a beneficial environment in which these young adults can learn, right? And so nobody has a right to go to Harvard. Harvard could decide we're only going to admit rich white guys, and they would still have to reject lots of rich white guys, right? There's like way too many of them. And they don't want a university class that consists only of rich white guys, right? Then that's gonna, like, what's gonna want to go to that school, right? Like, that's not a good environment in which to learn.
Besides rich white guys.
Exactly. So the universities are intentionally trying to select a diverse incoming class. They're not like rewarding seats to individual people based purely on merit, right? And there's a wide range of different kinds of diversity they consider. Every selective university in the country likes to advertise we have students from all 50 states and 100 different countries, right? And so sometimes they got to go out and look for those applicants from Nebraska or Montana or whatever, and maybe even give them a boost. Most selective colleges and universities have recruited athletes, right? Most selective colleges and universities give a boost to family members of alumni. That's the so-called legacy preferences. Most selective colleges and universities give a boost to family members of large donors, right? Or other politically connected officials, right? And so there's a wide range of factors besides grades and test scores that universities look at. But the way conservative lawyers and judges look at this is, okay, well, you can give a preference to children of alumni. Maybe that's a good idea, or maybe that's a bad idea, but that doesn't raise any constitutional concern. But the intentional and overt consideration of applicants' race, the conservative lawyers and judges say, that violates the 14th Amendment. Because the 14th Amendment, enacted after the Civil War, guarantees everyone the equal protection of the laws. And if you're treating a black applicant differently from a white applicant, you're violating that provision. And the true and proper understanding of that provision is that the Constitution is supposed to be colorblind, right? And government's not supposed to treat people differently on the basis of race at all. And so what this produces is a really rich and longstanding, and I think interesting and significant, important constitutional debate about the proper understanding of racial equality that was enacted into the Constitution after the Civil War. And the conservative justices, who in many contexts advocate that we should be adhering to the original meaning of the Constitution. In the affirmative action context, they have usually placed less weight on those historical arguments, because the historical evidence, and Ketanji Brown Jackson and Sonia Sotomayor document this in their dissenting opinions in this case, the historical evidence shows that the authors of the 14th Amendment themselves supported all kinds of race-conscious remedies for the recently freed slaves, right? And so they were trying to outlaw the racial subjugation of African Americans. They were not trying to outlaw any race-conscious benefit for members of a racial group who might need a boost from the government given past patterns, right? And so that's a really fundamental. Is the Constitution colorblind, or does the Constitution allow some carefully tailored race-conscious measures to benefit racial minorities? That's a very sharp divide on the court. Conservatives have been making their colorblind case for decades, and they finally had the votes to kind of really put it in place in a full form.
Yeah, and I think Ketanji Brown Jackson, her elevation to the court in the dissents are incredible, because I do think that she pokes hole in the originalist arguments that this conservative majority is always putting forward by actually going to the original intent of and she's been credited with a couple of these reversals, specifically the Alabama case that we talked about earlier. That her questioning and in oral arguments may have saved the day, and by trying to take an originalist argument and put it back to the supposed originalist wing of the court. So, but now we get to 303 creative, which again, I'm going to editorialize, in my opinion, for the first time, allowed discrimination against a protected class based on, for businesses that are in the open marketplace. And, this one has some interesting, backstory to that. It's just how it is only recently coming to light that the case may have been based on total fiction, not just the theoretical fiction of what was going on. But why don't you talk a little bit about that case?
Yeah. So there's a long running series of suits filed by conservative litigators, especially litigators associated with conservative evangelical groups like the Alliance Defending Freedom, which is the one that brought this case, where they use both the First Amendment guarantee of religious freedom and, or depending upon the case, the First Amendment guarantee of freedom of speech to try to argue that anti-discrimination laws enacted by state legislatures or even local governments or even Congress potentially, right, even federal civil rights laws potentially, that these anti-discrimination laws, if you apply them to conservative evangelicals, it has the effect of violating their rights, right? And so if you think about so this is not just a recent thing. This is not just a thing with the Trump justices. These issues have been around for a while. There was a case back in the 90s involving the Boy Scouts, right, where the Boy Scouts said we're not going to have any gay troop leaders. And New Jersey had an anti-discrimination law that says you can't discriminate on the basis of sexual orientation. And the Boy Scouts challenged that law, and they won in the Supreme Court decades ago. On the argument that the Boy Scouts is a private, expressive association. They have the right to be opposed to homosexuality if they want, and the state can't force them to undermine their own message like that by hiring gay troop leaders, right? So LGBT rights advocates have always bristled at these decisions, and then the court has moved. On the one hand, the court over time has become more protective of LGBT rights with the marriage equality cases and the like. On the other hand, the court has, with Trump's appointments, has moved in a sharply more conservative direction. And Gorsuch and Barrett in particular are very attuned to perceived discrimination in their minds or silencing of conservative religious voices, right? And so there's been lots of cases like that before this one. And so the fact that that I'm going to talk about in a second, that you alluded to, that the facts in this particular case were basically contrived, is like, on the one hand, troubling. On the other hand, even if this case hadn't gone forward, there's going to be more of these cases anyway. So but so it turns out that the plaintiff, the litigant in this suit, was a website designer who said that
allegedly website
yeah,
designer. He hasn't designed one website yet, but yeah, go ahead.
Who said that she wanted to be running a business designing websites for hire, and that included in her business plan would be designing wedding websites, but that she was ideologically and religiously opposed to same-sex marriage, and so she didn't want to be forced by the state to serve gay couples who were getting married and wanting her to design her website. And that a website is an inherently expressive endeavor because it involves writing words and putting them together with images and posting them on the website. And so if she had to do that, if the state said she was required to do that in support of same-sex marriages, the state, she didn't say freedom of religion, she said freedom of speech. She said in this case, the state would be compelling her to express views that she didn't agree with. And the whole thing was contrived because she's never designed a wedding website, right? The state had never prosecuted her for anything, right? Never fined her for anything. And at one point in early stages of the litigation, there's a court filing that mentions a specific inquiry that she had received from a gay man looking to get a wedding website, right? And it turns out the reporter just called the person listed there that it was completely made up. He is not gay. He's already married, and he never contacted the website designer. Somebody just used his name and number, apparently. So that is fishy for sure. The reason I think we're still trying to get to the bottom of this, but I think the main reason that it didn't come to light until now is that in the initial stages of the case, Colorado has a Democratic attorney general now, but in the initial stages of the case, they had a Republican attorney general who was basically colluding with the litigant, right? They basically agreed with the lawsuit against the state, and so wasn't doing any kind of due diligence to see if their claims were actually real.
I didn't even hear that part. That's that's just amazing. Okay. Yeah. I mean, because his duty is to uphold the state law as an attorney general, whether he's what party he is or not. He's supposed to uphold the state law that was, I believe, voted on by
statute. Yeah, it's not, I don't think it's an initiative. I think it's a legislative statute. Yeah. And it's, whatever, there's more, again, I don't think we've gotten to the bottom of this yet. And there are somewhat more charitable interpretations of the attorney general's actions. Again, they knew that more suits like this were coming, right? Colorado has good anti-discrimination laws with lots of protections against for LGBT rights. And they've also got lots of religious conservatives. So this has been an ever-present conflict. And they may, what they did is they just stipulated to the facts. They agreed not to challenge or really look into any of the facts as stated by the claimants. And maybe a different attorney general would have done that differently. But they also maybe just were like, this case, if it's not this case, it's going to be the next one. Let's just get this issue decided. Either way, in terms of the specific case outcome at the U.S. Supreme Court, it doesn't really make a difference. Like, it's not the U.S. Supreme Court's job to figure out the details of all those facts. And if it wasn't this case, it would be a different one. And so that's not really the worst problem with this case. But it is just, I guess I want to say, just a symptom of, or an indicator of, the aggressiveness with which conservative lawyers and judges are moving, right? Like, they're like, we know that the current Supreme Court will rule in favor of free speech and rule against anti-discrimination laws protecting LGBT people. And so we just got to get a case back to the Supreme Court. Well, we already tried a case a couple years ago with an anti-gay baker, right? And the court didn't really address the main issue in that case. So we got to try again. What should we do? Should we do somebody who designs invitation cards, or somebody who caters weddings, or how about this website designer? That seems like it'll work because websites are inherently about speech, right? Let's try that. And then they just run with it. And again, there's no actual conflict. Like the state never did anything to this person, right? It's really just kind of fabricated in order to get the case to the Supreme Court.
Right. I remember with the Masterpiece Cake shop a couple of years ago, there was a lot of thought that maybe Colorado shouldn't have prosecuted this person to bring this case towards the Supreme Court. We should have found a different way. I know there was a lot, that gay customers should just not bring these lawsuits before this court, because you're opening up the anti-discrimination laws to challenge. But now you're seeing that it didn't matter whether they brought it or somebody else brought it or whether action was brought. They're going to hear these cases and they're going to act, they're going to overrule based on religious, supposed religious. I mean, it's like going back to the Hobby Lobby cases and all of these things that are just truly that they're just using religion as a reason to justify discrimination.
That's right. And the one other thing I'll say about this one is that it's very hard to figure out like what the limiting principle is here. I mean, it's a real conflict. It's really true that like there are situations, maybe including the Boy Scouts case from the 90s, but that there's like sort of important kind of rights and interests on both sides of some of these cases. That's a real thing. There's reasonable disagreement about how to properly draw the balance between First Amendment rights and non-discrimination principles. That's not just made up. That's a real thing. And yet, once you start using a sort of robust reading of First Amendment speech and religion rights to limit anti-discrimination laws, it's very hard to figure out like where you're going to stop, right? And because like, I mean, back in the 60s, when Congress was first passing laws protecting against discrimination on the basis of race, right? White supremacists argued over and over again that their discrimination on the basis of race was rooted in their religion, right? And the court rejected those arguments back then. And they were like, okay, but yeah, if you're operating a business that's open to the public, the state, their federal governments, they can tell you to keep your religious views to yourself, right? You can't exclude people from your lunch counter or your restaurant on the basis of race, right? Like, so I think Justice Gorsuch does not want to undermine that. He doesn't want to bring back like white supremacists, like religiously motivated resistance to anti-discrimination laws on the basis of race. But like, why is that one not allowed, but this one is? Like, I think Gorsuch just thinks about, discrimination on the basis of sexual orientation or gender identity. He thinks about that differently than he does discrimination on the basis of race. But it's not clear what the logical difference is between those two. And so these cases are not going to go away. And what you see in a lot of these cases, and this might actually be a good, I don't know how we are on time, but if we need to wrap, this is a good kind of takeaway point. In a lot of these cases, there's a very clear sort of like to be continued vibe, it's like how far does the court's free speech principle in 303 creative go? We don't really know, which means there's going to be more lawsuits, and there's going to be further attempts to carve out protections for conservative religious folks against anti-discrimination laws, and the court's going to continue deciding cases in this vein. Same with affirmative action, right? The universities are going to try to come up with race-neutral means to continue to assemble a diverse student body, and the conservative litigators are going to challenge those policies as well. They're going to say, you call it race-neutral, but really it's just subterfuge, and you're doing it because of race, So all of these cases seem like they're raising issues that are going to keep coming back to the court.
Definitely, it is increasing the billable hours for conservative attorneys across the country here. But all right, and we did talk about the student loan in the lead up. We talked about the major questions doctrine. I don't think there's a lot more to get into that one, other than it is, again, it seems like it's a Democratic president making law, using the law in the same way that other presidents have used, but it's a Democratic policy. So now all of a sudden it's not good. And we are running a little late, but I didn't want to let you go without talking about the ethical, things that are happening, because this is not happening in a vacuum. And the court is losing its legitimacy in the eye of the public. For the first time, I saw a poll this weekend where a majority of the respondents said that this court is acting politically, not based on merit. And that's the first time we've seen that really in American life, at least in my time period of watching the court the way it is. And part of that is because of the ethical issues around, Clarence Thomas and Sam Alito, who are lockstep with all of these bad decisions, or even with the good decisions, they're on the bad side. They are the most consistent conservative votes. I mean, they voted for the independent state legislative theory, although they said it should be moot. They did a lot of, they've been on the other side of this. Yet now it's coming out that they've basically been sponsored by billionaires. They're getting all kinds of benefits that they're not following disclosure laws on. I wanted to give you some time to talk about that.
And let me say what I think is the one key takeaway about these ethics controversies, because I'm sure some of your listeners have already kind of read about the details a lot. But I just want to sort of pull one thread out. So there's been a series of recent articles, mostly broken by ProPublica, focused mostly on undisclosed gifts to the justices from wealthy benefactors and stuff. But I also want to remind folks about, there was an earlier set of articles, I think first broken by the New York Times. This was last fall, talking about an earlier period. But there was this guy, Rob Schenck, who was a conservative evangelical, who it turns out was sort of grooming billionaires, grooming rich donors to try to insert themselves into the justices' lives, right? And he has now sort of recanted, and he feels bad about all these efforts. And so he's been talking to journalists about them. But he said over a period of years, he would recruit wealthy conservative donors, encourage them to make donations to the Supreme Court Historical Society, which is a charitable organization that is dedicated to maintaining the Supreme Court's image in the public mind or whatever. And they hold these big gala events in DC with the justices, and the donors get invited, and then they meet the justices, and he's like, yeah, befriend them, and then try to go out to dinner with them and just talk about conservative stuff with them and just try to keep them on the right path, right? So that was years ago. That was in the 80s and 90s. One of the common themes, one of the characters who keeps reappearing in these more recent stories is the Federalist Society guy, whose name I'm actually blanking on at the moment, Leonard Leo. So Leonard Leo is one of the leaders of the Federalist Society, and he was at the retreat with Harlan Crow and Clarence Thomas. He's in the painting. He's one of the guys in the painting of Clarence Thomas and Harlan Crow hanging out at his retreat in the Adirondacks. He was one of the guys who connected Alito to the guy who hosted the Alaska fishing trip. And so both Rob Schenck and Leonard Leo, who were conservative activists, both of them, they were running years-long influence operations at the court, right? Where they were the matchmakers. They were the ones introducing the justices and the conservative donors to each other and facilitating those connections. And then, so the justices then not reporting these gifts, that's shady. But the sort of underlying kind of backstory is even shadier, right? It's basically wealthy Republican donors trying to buy the favor of the Supreme Court. And whether anybody could prove that any justice made a specific decision because of that does not matter, right? The hedge fund guy who was fishing with Justice Alito had a multi-billion-dollar case at the Supreme Court where the court ruled in his favor. But it doesn't matter, right? Because the issue with judicial ethics is the appearance of impropriety. And I don't care if Alito thinks he's straight as an arrow and he never changed a vote because of any of these fancy fishing trips. It looks bad, right? It looks like the court is bought and paid for. And that, by all traditional accounts of judicial ethics, that is something that judges are supposed to steer well clear of, right? Don't take expensive gifts from fancy rich people whose cases might come to your court because it just looks bad. It creates an appearance of impropriety, and you should steer fully clear of that. And the current justices have been flagrantly trampling those norms. And yes, that I think is one of the reasons, along with the consistent conservative results in all these politically charged cases, that is one of the reasons why the public appears like it's turning against the court.
And we would need a whole nother podcast to go into, the many reforms that we've talked about before, but we don't have time for that right now. But I do think that we are seeing a possible movement at least in the Senate to bring up Supreme Court ethics reforms. But would we need a House vote for that as well? Or so it could be dead in the water because of the way the House is structured right now?
It's dead in the water for now, but the fact that Durbin, who's the Democratic chair of the Senate Judiciary Committee, he has promised this month, if I understand correctly, to hold markup on an ethics bill. Durbin is kind of a moderate institutionalist Democrat, and the fact that he's come around on that is a sign of increasing support, again, still just on the Democratic side, but increasing support for doing something about a court that seems out of control. And even though it can't pass in the current Congress, the Senate Judiciary Committee getting over that hurdle is one big hurdle, right? And then is the Senate maybe going to pass something this year? Well, probably not because of the filibuster rules, right? Is the House going to pass something this year? Certainly not. Right. But then how does next year's election go? And what does Congress look like after that? And it's going to be a multi-year fight. But ethics reform should be the lowest hanging fruit of all the different kinds of court reform proposals out there. In theory, you should be able to get even some Republican votes for just tightening up disclosure requirements and the like for the justices. And even if it has only a modest substantive impact, it's a signal to the court. It's like, look, you guys got to rein it in a little bit. And so that's the hoped for sort of short-term path there.
One last question, then I'm going to let you go, because in the wake of all these decisions and the ethics reform, of course, expanding the court has been the most common refrain on Twitter and Facebook and all of that. But again, it's not, not the number 9 is not in the Constitution. It's not, the filibuster is no longer something that is held for Supreme Court nominations. Would the mechanism then just be to expand the court just to the president nominating 4 people tomorrow and then having a Senate vote on it? Or is there a legislative change that needs to happen that the House would have to be in favor of as well?
Yeah, you need a legislative change, right? The Constitution doesn't specify the size of the court, but it's specified by federal statute.
That's right.
And Congress used to change it regularly. In the 19th century, they changed its size 7 times. But the last time was when Ulysses Grant was president, right? So it's been a while, right? FDR famously tried to do it, but didn't get that through. And so the last thing I'll say about this, just to close, is if folks want to read something current on this, I recommend, there's a great recent report by the Brennan Center focused on term limits for the justices, but the size of the court and the length of terms of the justices are very closely interlinked, right? Because part of the problem is we have not enough justices and they stay on there for too long, right? They live longer than they did in the framers' day, right? And so and if you ask the public, do you think Congress should expand the size of the Supreme Court? There's usually majorities that say no. If you ask the public, do you think there should be term limits for Supreme Court justices? There's usually strong majorities that say yes. And the Brennan Center has a really interesting report that sort of links those things together in ways that I think Democratic legislators will give a look to if and when Democrats ever have full control of Congress again.
So again, we'll talk again. We'll have you on. I think you're one of my more frequent guests. So we'll have you on later this year, maybe when the new term of the court starts, and we can talk about fixes then. But again, the top line is larger Democratic majorities in both the House and the Senate, and in the Senate, a Democratic majority that will fix the filibuster for these legislative fixes is the only way that you're going to see maybe even ethics reform get through, or expanding the court, or term limits or anything like that. So
that's right.
Tom, thank you so much for coming back on, and as always, giving your time on this very important issue. And I hope to see you in better days, but if not, my therapy sessions with you are always very well received. So thank you very much.
My pleasure.
And that was my interview with Professor Tom Keck. Always good to have him on. He's just a wealth of knowledge, and it made me feel a little better, only because I know that there's people like him out there that I can turn to and get answers from in times when this is pretty, dark times when it comes to the Supreme Court. I am trying to get back onto my content schedule. So this weekend, I'll be doing a weekly wonk on the annual report from 2022, mainly focusing on the budget and staffing performances over at the Onondaga County Board of Elections. And then Commissioner Nakar next Tuesday. And that'll be dealing with the wrap up of the primary election, and probably, hopefully, the wrap up of the hand count, if that occurs as well. And then, of course, my next Zoom with Czarny is with the county legislature, Mo Brown. He is just won his primary, but he's not county legislator. He's running for county legislature in the 15th district. He just won his primary, and he's going on to the general election. And he's a good friend of mine, and I'm very happy to bring you that interview, as I'm going to start getting into these Zoom with Czarny's are going to be again focusing on the candidates that are running for office this year. So thank you very much. Go to DustinCzarny.com to subscribe. You can get email notifications for all election news and content updates. And I got a lot of things going on this month, so tune in. You're going to get all the information. Thank you very much, and enjoy the rest of your day. Bye-bye.